let's just cut to the segment. So, on this segment of Adventures of Eugene and Ev, we're going to discuss my time at Claro. I know you said that your company runs Claro, right? Can you break down Claro to the? I feel like I'm gonna butcher it.
Okay, so basically, Claro, it stands for
Civil Legal Advice Resources Office.
Yes. So basically, the idea is Claro is a civil legal resources clinic that helps people with their consumer debts, because the premise is that out of all the consumers in New York State that have, or all the consumers in New York State that have cases in civil court, right? Mm-hmm. So we're thinking generally credit card debts. Only 1% were represented.
One sec. Yeah, go ahead. Only 1%?
Only 1% were represented by attorneys. So it was a clinic set up to basically provide information to those people, and then also help people with motions they may have. And then we have another program called Volunteer Lawyer for the Day, where attorneys in my organization and volunteer attorneys will actually go in and litigate these cases for these people, as in they will have trials for these people, or attempt to settle their cases so they can get the best offer possible. Yes, and really holding banks' feet to the fire.
And I participated in both those programs, and I would say the biggest thing that was a shocker to learn in being in those programs as an attorney, or I was in law school at the time, was that a lot of times credit card companies will sell your debt, right? And once they sell your debt, I think this goes back to what you were saying before. These companies that buy the debt, they own the debt, but they can't prove. They don't get. From my understanding, because I haven't done it in a while, they don't get the proof of how much the debt is really owed, or any of the papers that would really prove that you actually own the amount of debt they say they own. Is that actually a fair description?
Yes.
So how does that play a role in bankruptcy?
That's not always the case, though. Sometimes if they can't prove, then they can't prove. But sometimes they can prove. It depends, what kind of documents they got from the original lender once they pass it down to you.
Yes, I feel like the
same thing in foreclosure too, basically.
But yeah, in bankruptcy, it's kind of like the same thing as peer. I started recently doing this because I filed a case recently, and I got a bunch of credit cards from 2000, 2004. I'm like, what is this? And then they have to attach a proof of claim, and they have to attach a bunch of documents to substantiate that they own the debt and that my client owes it to them, and they don't attach anything. If they don't have enough proof, that they acquired it, their original, whatever, and any transactional history, most likely they can't get the claim in, and you can object to the claim, and if the judge sides with you, you don't have to pay it back.
Yeah, because I guess my understanding was that what happens is they'll buy the debt, but legally speaking, let's say they're buying it from Citibank. Mm-hmm. Citibank can only provide them with a certain amount of documentation legally. I guess some of the documentation they can't give it to them. At least that's what the attorneys were telling me, which is why if you find out hey, this is this debt collector that brought the debt from Citibank or from whatever bank, and you ask them, all right, well, show me what proof that you have that you actually own the debt, a lot of times they won't be able to provide the proof because they don't get it from the banks.
Obviously the first thing, debt 101 is you need the promissory note, right?
Exactly.
And if they don't have the promissory note, because they have to provide the promissory note. If they don't have the promissory note, then they can't prove that they're standing. And that's like foreclosure work. That's foreclosure work 101. Do they own the note? Or because they generally provide copies with when they file a case with the summons and complaint. Mm-hmm. But can they provide enough evidence that they own the note, and can they provide proof of default? So basically the agreement you made and proof that you stopped paying, right? So even, a lot of times they'll have the note because they'll sell the note off. They'll, just sell the note off. But where's all the other documentation showing that this individual hasn't paid? Do you have a concise payment history, for that individual? You have letters, you have other documentation, and I don't want to really get into the legalese of it, but basically, can you prove that person stopped paying?
Yeah. Okay.
And that's what it is, and the amount that they owe.
Okay.